Hi everyone, my name is NUR KHALIDAH DAHLAN. I'm from Faculty of Law UKM. Today I will presenting my topic of presentation, that is tourism and alternative dispute resolution. Tourism and hospitality industry has been recognized as one of the major factors contributing to the country's economic growth. The emergence of travel agencies from the government and private sectors are also been successful in attracting consumers in Malaysia. Based on the statistic released by the Department Statistics of Malaysia, shows that numbers of domestic and foreign tourists has recorded an increase from 2010 until 2015. The statistics is based on before the pandemic COVID-19 occurred lah. The numbers of visitors are total of 176.9 million visitors in 2015. Tourism law in Malaysia usually concerning dispute that occur often associate with cases of fraud or misunderstanding among the parties involved. Yet when looking at the provision of the law, there are various key acts that can be referred to in order to reach a settlement. The legal reference used are not only focus specific statutes, but are contained in several acts such as Tourism Industry Act, Contract Act, Consumer Protection Act. Therefore, as a result of existence of this issue of infringement, detailed research need to be concluded. In identifying law, they are able to preserve the right of consumer as well as able to provide remedies in exchange for losses suffered by them. Main statutes that usually apply to control and protect the tourists or consumer in terms of tourists are Tourism Industry Act 1992, which involved with the consumer holidays contract, including cancellation of booking, amendment charges, deposit and others. Nevertheless, in 2021, the Act has also not been amended for 20 years, and it is no longer in line with the current tourism landscape, which is after the during the pandemic and after the pandemic COVID-19. The next main statute that usually dispute in tourism refer are Consumer Protection Act 1999. The Consumer Protection Act provides for matters relating to the protection of consumer. It also established the National Consumer Advisory Council and the Consumer Claim Tribunal. Okay. The third main statute is Contract Act 1950. However, this act still does not cover all aspects of contract law concerning with tourism. This is because the Contract Act does not contain any provision that deals specifically with the content of a tourism or tourist contract. Now we go to what is ADR or Alternative Dispute Resolution. Alternative dispute resolution process are a variety. The common theme is the empowering nature of the process, which enable the parties themselves to determine the outcome and solution to the dispute. The prospect of win-win solution is a powerful incentive for the parties to try ADR first. The three main or better known method of alternative dispute resolution is negotiation and arbitration, and also mediation. Now we go to the methods of ADR. Negotiation is the most common ADR process. The process is voluntary and the party has the greatest flexibility over a range of issues. Okay. Next is the mediation. Mediation is assisted for facilitated negotiation. The parties meet face to face in presence of the neutral third party, the mediator, who tries to help them isolate issues, identify common interests, and generate option for settling the dispute. The third method of ADR is conciliation. Conciliation is conducted by conciliator, which a party to a trade dispute shall not in any conciliation proceeding be represented by an advocate, advisor, consultant, or by any other person whatsoever. The main difference is that the neutral third party, the conciliator, is usually an expert with experience in the subject matter of the disputes. Recent development in Malaysia is the Pusat Mediation COVID-19, or in English, the Mediation Center for COVID-19. It is an government body that to assist public in resolving their dispute in respect of any inability to perform contractual obligation arising from any of the categories of contract. The categories of contract is specified in the schedule section 7 of the temporary measures for reducing the impact of coronavirus disease Act 2019. Okay, the dispute sum for the mediation process under Pusat Mediation COVID-19 should not exceed 500,000. If the dispute parties have a dispute value over 500,000, what is the avenue available to them? They can refer to the Malaysia Mediation Center or ASEAN International Arbitration Center or any other private mediators. As conclusion, most laws may or had been through amendment on the contractual provision in certain acts to ensure the law take into factor the current COVID-19 pandemic crisis in Malaysia. However, how it might affect the contractual relationship between the parties is currently undergoing the process. As for the outcome of the above issues, which is tourism dispute, the decision possibly will be different if the parties would settle their dispute through the process in Pusat Mediation COVID-19. All the parties will definitely make a compromise solution that will fulfill all parties' need. Due to the foremost purpose of ADR is to resolve any dispute that would lead to win-win situation. Thank you everyone for listening. That's all for my presentation. Thank you for listening. Hope you enjoy my presentation.